Wow, it has been some day here in the Law&Crime Network with this Jonchuck trial, and we are so fortunate to have Josh Solomon back with us again from the Tampa Bay Times. How you doing, Josh?
Bob, I'm well. How you doing?
Okay, listen, I got to ask you, brother. I mean, from this end where we're sitting and watching this, we're seeing a courtroom that's out of control, lawyering that's kind of out of control, a lot of flashy, hot, sparky stuff going on. But Josh, first of all, tell me about the atmosphere. Is it as amped up as it appears to us?
Yeah, it really is. I mean, the emotions are high, appear to be high among the lawyers and the judge. The defense has been raising issues all morning, and the prosecution has seemed to be getting frustrated at the delays. Some of these issues are issues that we've addressed before, and so the judge seems to be getting a little impatient as well. And it really, in sort of a magnificent showing, boiled over right before lunch, where while the defense was making an argument, the prosecution, one of the prosecutors stood up, raised his voice. The defense lawyer sort of asked the judge to admonish the prosecutor. Instead, the judge admonished the defense attorney, and very abruptly, the judge called lunch. It was a moment that we hadn't seen before in this case.
Yeah, she asked the defense lawyer asked the judge to swat the prosecutor. You never swat a prosecutor. That's just like against your best interest. But asked to swat the prosecutor, sit him down. The judge then ordered her to sit down. She was in shock about that, and then exasperated. And that's how the judge appears to be all day today. She basically says, "That's it. We're taking a break." That's the judge's way of saying, "I can't take it anymore." Josh, I want to, again, sometimes I bend your brain a little bit here from some legal points of view, but I want to ask you this. Myself and my boy Gene Rossi have been debating the admissibility of a lot of this bad character evidence, and is the prosecution going just a little too far? And we were wondering why the defense lawyer was not objecting to it in front of the jury, but eventually she did and made the motion for the mistrial. But do you get a sense that the prosecutors are they should just lay down a little bit, that this may cause a reversal if there's a conviction?
You know, it's hard to say. I mean, they've been dealing with the defense several times during the trial, and even in hearings before the trial, have asked the judge to prohibit any testimony about Jonchuck being a psychopath. Asked the judge to keep out any testimony about his bad acts, but the judge, sort of has to weigh, well, how do we talk about how the defense is arguing, of course, that he's insane, that Jonchuck was insane at the time of the crime, and the state is arguing that he wasn't. So I think that the judge is trying to weigh, how does she allow the prosecutors to make their case about Jonchuck being sane and having motive and having premeditated the murder of his daughter, while also weighing his rights. And so I think that's what we're watching here, that battle of the competing interests, and the judge trying to find thread the needle here.
Yeah, I mean, but the due process rights go to the defendant, and I just, as a former homicide prosecutor, am thinking they don't really need to put all this bad character evidence in my mind. They're sacrificing themselves a little bit. But a question I have for you that we can't get from our end is the judge giving limiting instructions as this testimony is coming out? I.e., is the judge saying to the jury, you can use it for purposes of the expert's opinion, but you can't use it to say the guy's a bad character, and if he did those things, he must have done this? Is anything like that happening?
At this point, I don't believe the judge has given any instructions to the jury about how they can and can't consider certain evidence. There's been a lot of discussion with the jury out of the courtroom about what can be brought in front of the jury. For example, the judge will not let anyone call Jonchuck a psychopath. She thinks that word is too prejudicial. But there can be testimony about psychopathic traits, and so she's trying to parse the language to try to, again, thread the needle in a way that isn't too prejudicial against Jonchuck. But in terms of simply directing the jury about how they can and can't use certain evidence, there hasn't been that discussion.
Yeah, because typically speaking, the courts require that it be a timely instruction given as the evidence is coming out. Did the defense make that argument at all at the time that they made the motion for the mistrial, that the judge should have done that?
I don't believe they did. we'll have to see how the conversation. I mean, the conversation ended, prematurely. We'll have to see what happens, whether that discussion happens after lunch.
Josh, one last thing, just personally speaking, you're there. Do these lawyers look? They're slaying it out there. They're fighting. They're telling each other to sit down, swat each other. Are they personally friendly with one another, or does that animus also go outside the courtroom?
So Jessica Manuel, the lead counsel for Jonchuck, and Paul Boland, the second chair for the state, they actually went to law school together, and they've known each other for a long time. Most of the lawyers went to Stetson University College of Law, which happens to be in Gulfport, right near St. Petersburg, Florida. So I think they all know each other. But there are some heated moments. I don't know how it plays off the field, though.
All right, Josh Solomon, Tampa Bay Times, thank you so much, as always, for your excellent insights, because you're right in there in the middle of this fire. What a great trial to cover. Talk to you soon, Josh.